Right. I know we'll have folks continuing to join as we get started today, but let's go ahead and kick things off. Hi, my name is Jordan Bates Rogers. I'm the Executive Director at the Arkansas Access to Justice Commission and Foundation. And we're so excited to have Sarah Cowan presenting today on breaking barriers to recovery. Sarah is the staff attorney for Beyond Opioids. That's a project of the Center for Arkansas Legal Services. Before Sarah joined the Center for Arkansas Legal Services, she was a deputy prosecuting attorney in the 6th Judicial District, handling violent, property, drug, and juvenile cases. She's a graduate of the William H. Bowen School of Law, where she was a co-founder of the Arkansas Journal of Social Change and Public Policy, and was an associate notes editor for the UALR Law Review. She also has a business administration and English degree from Millsaps College in Jackson, Mississippi. And she's a member of the board of the Judges and Lawyers Assistance Program. She enjoys reading, working out, spending time with her friends and family. And one more thing before I turn it over to you, Sarah, just another reminder, in the chat, you will find the link where you can get materials. I'll post that one more time, and we'll post it a few more times throughout. That's where you can find the CLE form for today and the materials. And I hear someone saying the volume's pretty low. If anyone else is having that issue, let us know. Otherwise, you may just have to adjust your individual volume up. And with that, I'll go ahead and turn it over to Sarah. And Sarah, I believe you did say you want folks to interrupt if they have questions. Is that correct?
Yes, and I'll try to keep an eye on the chat, but I know you will too. Okay, I've never been accused of speaking too quietly. So if that is the case, let me know, but I think we probably should be good. So I am Sarah Cowan. I work for the Center for Arkansas Legal Services, and I work on a special project called Beyond Opioids. And so I will start just kind of with a little information, oh gosh, about that. Oh, okay, I've got it figured out. I am a baby boomer trapped in a millennial's body. And so this may be a little bit challenging for me, and Jordan has been very helpful. So I will do my very best. Oh, and I'm sorry, I cheated. We were gonna have a poll on this question, but I'll just go ahead and give you the answer because of my PowerPoint skills. So as you can see, the nationwide average of opioid prescriptions is 46.7 for every 100 people, which in and of itself is a pretty high number. If you'll see there, the Arkansas opioid prescription rate is nearly double that. We are right up at the top of the list of the states who have been most impacted by the opioid crisis here in America. And so as you'll see too, approximately 50% of any Arkansas legal aid clients are impacted by substance use disorder. And you'll hear me say that a lot today. We've got substance use disorder, opioid use disorder, alcohol use disorder. And that's really an effort to get away from some prior kind of stigmatizing language that was really in place to describe people who deal with these kinds of issues. Oh my God. Okay, so virtually all of the legal aid organizations in the country provide services to people affected by substance use disorder. And so here in Arkansas, we have some special programs for folks with substance use disorder. And you may have heard of things like drug court, DWI court, mental health, veterans, and those are more aimed at being kind of rehabilitative options rather than punitive. We as a legal aid organization don't represent clients in those. We have various funding regulations from our national organization. And so we aid clients in civil legal intervention in a variety of subject areas, save for a few. So the way that this project works is it's a collaboration between the two legal aid organizations of the state, which is us, the Center for Arkansas Legal Services, and Legal Aid of Arkansas. So you can see there on the map, there's a, that kind of shows us who's in charge of each service organization. This particular project, Beyond Opioids, is funded by the Rural Community Opioid Response Program, the grant that we received through HRSA, which is the Human Resources and Service Administration. We were awarded $2.2 million for a 3-year period. And so we use that money to provide civil legal services exclusively to people in either rural counties or parts of what are deemed to be metropolitan counties that have rural tracts in them. And so this particular project is really to address this huge need that we have in less urban areas. But the presentation as a whole will kind of just focus on addressing these issues for all SUD clients. And so again, Beyond Opioids, it's a partnership between CALS and Legal Aid. It works with our legal aid organizations and some partner agencies. And so we have what we call a two-way referral system, where some of these partners that we work with who are kind of on the front lines with people who experience these SUD, OUD issues. And, these are places that are providing more of the therapeutic angle, but they're working with clients who are aware of their legal needs. And we work in partnership with them for them to refer us and see what kind of legal intervention that we can provide. So there are several things that we kind of see over and over as far as things that hinder a person's recovery process, not merely just abstaining from drugs and alcohol. And these are civil issues that we deal with here in our project. A lot of people receive driver's license suspensions as a result of criminal charges they may incur during their active use. We have a lot of people who need help with family law matters. Those are both for our clients who are in recovery from substance use disorder, but also the loved ones of people who are affected by someone else's substance use disorder. Kind of back in line with the driver's license suspensions, a lot of our clients may have in their past either a misdemeanor or felony conviction, and whether it's for assistance with housing or getting a job or just peace of mind, we help them with getting their records sealed. You may have heard this called expungement before. We don't directly deal with this next piece, but one of our partners, ACC, which is the Department of Community Correction, does in fact work with folks who've been in the criminal justice system. And one thing they see a lot is people who are hindered in moving forward by these probation fines, these fees, these restitution related to their prior cases that are sort of standing in the way of their recovery. And finally, just securing stable, safe housing. Okay, so let's do driver's license suspension and reinstatement. So as you can see, there are a plethora of reasons why someone's driver's license may be suspended. Obviously, most frequently in our program, the reasons that we see are people with a controlled substance conviction, because that's mandatory under the statute, and just the same with the DWI or BWI, voting while intoxicated, which is also mandatory. So is the refusal to submit. The rest of them are more kind of traffic related things, except for this kind of catch-all that accounts for other convictions. So why does a driver's license suspension hurt a client in SUD? Well, some of those specialty courts that I mentioned before, they really require people to show up quite often. And when transportation is a barrier, they aren't able to meet all the requirements of the program, and failure to complete those puts them back kind of in the mainstream court system that is a little less focused on rehabilitation and therapeutic options. Typically, the driver's license suspensions that we see are 6 months in length. That is the standard suspension that you get, say, for the criminal offense that requires a suspension or a DWI or the refusal to submit to a chemical test. Now, if you're already on a suspension and you get pulled over for driving on a suspended license, that's going to lengthen the time of the suspension. And I'm trying to find out where my poll questions are so I don't give any of them away again like I did the first one. Okay, good. I'm not in danger of that yet. Okay, so how do you get a license reinstated? Honestly, it is such a convoluted, complicated process that this isn't technically, I guess, a legal process. We don't go to court for this, but a lot of our clients are, in addition to being low income, which is the population that is served by a legal aid agency, they've also just really been dropped in the system with no guidance and no idea where to get guidance on how to navigate this process. So a lot of what we help with is, we'll get their permission to contact driver control on their behalf and find out how many fees do they have left to pay? What are their outstanding fines? Are they at various courts? How do they go and pay them? And so usually, kind of like I said, so the way you get your license reinstated is when you get it suspended, you are notified of that. There are time periods that you have to wait, whether it's 6 months or something longer, pay the fines, the fees, and there is a reinstatement fee of $100, and any other requirements that were placed on you as a portion of that conviction that led to the suspension. And so next, probably the area that we deal with the most in Beyond Opioids is going to be the family law piece. So when I say family law, I mean matters, again, that affect both the client who is in recovery from an SUD, as well as a loved one, household member, family member who has been affected by that person's SUD, and maybe they're stepping into a new role in their family, providing care that they otherwise wouldn't have. And so in that situation, that's going to be a guardianship. So my practice in this program is exclusively family law, and I do a lot of guardianships through Beyond Opioids. So the purpose of a guardianship is for one person to step in and make sure that another person's, kind of day-to-day stuff is taken care of, as well as property if the person has one. There are minor guardianships and adult guardianships. Typically, we're doing minor guardianships where a child's parents are in recovery, are incarcerated, are in active use. Typically, the purpose of the guardianship in this particular area of the law is going to be adults who want to make health decisions and educational decisions for grandchildren, nieces and nephews, that sort of thing. And the doctor's office or the school won't let them do that without some sort of proof that they are, in fact, the guardian. So the place that you file the new guardianship action is going to be in the county where the proposed ward, i.e. the person who's subject of the guardianship, is domiciled. And so you see it says proposed ward or alleged incapacitated person. The latter refers to the person who's subject to an adult guardianship, while the former is going to be a minor guardianship. So how do you qualify to be a guardian? You have to be a resident of Arkansas. You have to be at least 18. You have to be of sound mind, which is not explicitly defined. And you cannot be a convicted or unpardoned felon, except in certain cases where the potential guardian provides a copy of the sentencing order to the judge in that case to review, and then the judge determines whether the proposed guardian is able to proceed with pursuing the guardianship or if they are restricted from it because of that rule. So for a minor guardianship, the requirements are pretty simple. The proposed ward is under 18, i.e. minority. The proposed ward is unmarried and unemancipated. So the way a court determines whether the guardianship is necessary is pretty simple. Is the natural parent qualified and suitable? If not, the guardian's got to be qualified and suitable. And then you'll hear this a lot, but what's in the child's best interest? So statutorily, there is a natural parent preference that says the law assumes that, the law assumes essentially that a natural parent is fit to parent the child until it's proven otherwise. And so in a lot of these cases, you'll hear fit and unfit because there's been a long line of jurisprudence in which people ask for the court to make a ruling that the parent of the child in the minor guardianship is unfit. But there's been recent case law that came out in June that's basically gone through and said, this verbiage may be in a lot of these cases and in these orders, but we've really, and I have a quote, it says, 2865-204, which sets out, the considerations. It says it makes no mention of whether the natural parent is fit or unfit, as those terms have been used in custody cases. And again, the sole considerations in determining guardianship pursuant to 2865-204 are whether the natural parent is qualified and suitable and what's in the child's best interest. So that standard of fitness, you'll kind of hear that a lot, and people still refer to that, or courts still refer to it, but under this recent case law, that is not a benchmark that has to be shown, that the parent, from whom guardianship is being sought is unfit. So there are also adult guardianships, and there's, situations with SUD, OUD clients. This is going to be typically when someone is in active use and aren't able to make educated decisions for themselves, for their health, for the disposition of their property. And so the requirements are all the same in an adult guardianship, with the additional requirement of an evaluation by a healthcare provider who has worked directly with the alleged incapacitated person. And so, it's got to be done within 6 months of the final hearing on the guardianship that's held. And there are a few different service requirements for adult guardianship that don't necessarily apply to minor guardianship unless the proposed ward is 15 and over. And those are really specific notice requirements. And those are all set out in the code for exactly what needs to be in the petition, how it needs to be served, et cetera. So one thing that I do fairly often is emergency guardianship, especially in cases where my client is the family member, the loved one of somebody who does have the active use, and there's a concern for the child's safety. And so you are required to submit an emergency ex parte motion that can either be a verified petition or accompanied by an affidavit. You have to set out in pretty specific detail why there is an imminent danger or threat, to the health of this person, and that, this does loss, damage, waste to property. The majority of my clients, who are seeking custody of a minor, or guardianship of a minor, the child doesn't really have any property to speak of. And so once the petition is filed, an emergency ex parte hearing can be held. If the court grants the emergency hearing, then there has to be a temporary hearing held not to exceed 14 days from the date the court enters the ex parte order related to the ex parte hearing. And so the court can extend a temporary guardianship up to 90 days upon the presentation of clear and convincing evidence that it's necessary. For adult guardianships, that rule is just the 90 days. For minor guardianships, if the court has ordered a temporary guardianship of 90 days, as long as the court is petitioned before the expiration of the 90 days, it can extend the temporary guardianship up to 180 days before the final hearing is held on the matter. And so that can either be done on, the merits of the moving party, or if the petitioner and the respondent agree to extend the temporary guardianship a little bit longer. The other thing I see a lot with my clients is divorce. And the majority of these, well, that's not really fair. I guess it's kind of half and half between people who are in recovery and maybe, this is something they neglected to do while they were in active use, even if they have been separated from their partner for a significant amount of time. A lot of times my clients are the spouse of someone who is either in active use, recovery, or kind of both. They kind of go back and forth. And so a lot of strain is put on partners, family members of people who are experiencing substance use disorder. And a lot of my clients they wait a long time to reach out because their partner has sought treatment and experienced a relapse, that sort of thing. And so I see a lot of people give their partners lots of chances because they really do, want them to enter recovery and have a pretty successful, time after they get treatment. And sometimes it works and sometimes it doesn't, unfortunately. So obviously divorce is pretty complicated, but just some of the basic requirements for a divorce case. The person, the plaintiff seeking the divorce, has to have lived in Arkansas for 60 days before they file their complaint for divorce. They have to be separated from their spouse. And again, with my particular client base, this is a detail I often kind of have to check back in with people a good deal, because the nature of active use and of relapse the parties could have moved out, say one could have left the other 15 months ago, but, there may have been a weekend when the person with the substance use disorder wanted to come and visit the kids, or, the parties may spend a night together, and that starts the clock all over again for the separation. So you do have to prove, allege and prove grounds in the state of Arkansas. And there are several different grounds listed in the statute. The most common are general indignities or separation for 18 months. So what do general indignities look like in substance use disorder cases? Typically in these, more often than not, I guess I am representing the party who is not the person who's in recovery or active use. And so the majority of these general indignities manifest themselves in, say, erratic behavior by the person who uses controlled substances or misuses prescription drugs. A lot of that erratic behavior can just be anger, yelling profanity at the other party, a lot of like mental torment and abuse. But, depending on the substance and the person's reaction to it, it also manifests itself a lot in physical violence. And so unfortunately, I do see that a lot with people who are the partners of someone in active use. And this is an issue that's experienced with non-SUD clients, maybe who experience domestic abuse outside of the realm of substance use disorder. But, I often have to check back in with folks because they will want a divorce, and then their partner will tell them, well, I'm going to treatment and I'm going to participate in an ongoing recovery program. And so they put it on hold. And then the person may leave treatment early, or the person may not participate in an intensive outpatient program or a 12-step program afterwards. And for some reason or another, their recovery is not successful. And a lot of people can go back and forth on this multiple times. And I do have several clients who have finally, and they will just say, look, I've tried to do this before and he's promised X, Y, or Z. And this time is the last time. Excuse me. And even if his efforts are successful, or her efforts, we've just gotten to the point where we can't go any further. And so like in any other divorce, the issues that we have to decide are custody of the parties, whether the non-custodial parent is allowed visitation with the children, any kind of child support or alimony, and property and debt division. And so I will say, because our client base typically is 125% of the poverty level, with this particular grant, we can extend that a little bit higher to serve more people. But there isn't often a lot of significant assets to be divided in this population. I mean, often these parties have been separated for so long that everyone just kind of keeps what's in their custody and calls it a day. We do see some debts a lot with, like if the person, when they were in active use, or if they still are, debts that have been taken out that then have to be addressed in the process. So recently the law, I guess probably a lot of people are familiar with that. The law has changed where Arkansas essentially favors joint custody. That is a rebuttable presumption now, that joint custody is in fact what's in the best interest of the child. This presumption can be rebutted by any kind of clear and convincing evidence that it's not in the best interest. Can be rebutted if the parties can reach an agreement on all custody issues, so the court is not making a determination there. One party doesn't request sole, primary, or joint custody, or it's like a double negative almost. There, later in the statute, there are two other rebuttable presumptions that a sex offender or a person who's committed domestic abuse should not be in a custodial situation. And so if those presumptions have been, if the rebuttable presumption has been rebutted that that is not the case, then anyway, I almost can't even explain it, like all the double negatives. I would just like instruct you to view the statute on that. So what does the best interest of the child mean? Is there domestic abuse? I see a fair amount of this in my cases, again, because of volatile behavior that can occur when people are in active use of whatever controlled substance or misused prescription substance that they are experiencing an issue with. Who's been providing the majority of the care? What kind of character do we have of the parents? What sort of environment are the parents, having the children around? That's a concern that we have to address in divorce cases, custody cases, guardianship cases, because when people are still in active use, a lot of the time they are unstable in their housing. They don't have stable and safe housing. They may be transient, and sometimes they will take their kids with them. And it's not the safest environment for children to be in. Children crave stability. There is a child's preference that relates to older children who are able, to make that sort of decision. And then they will also look at, considerations about keeping multiple children together when making a custody decision. So what sort of, again, custody visitation issues do we see? We see people, and again, I know I've been talking a lot about people who are still in active use, but we also serve a lot of clients who are in recovery, and that's a real pleasure to see someone who has really worked on, their substance use and, is able to be in recovery and work on different aspects of their life. And so a lot of times we see those people who want to reestablish custody. They've lost that because of their substance use disorder. Some of the other reasons we'll see are custody modifications when the person is in active use, unfortunately. And so we do see those a lot. So there are some special considerations when you're looking at these family law cases for clients with substance use disorder, opioid use disorder, alcohol use disorder. Is the client in active use? I mean, that probably seems like a given. The court's going to want to see, can you pass a drug test today? And often the courts are using things like hair follicle tests, fingernail, toenail tests that can really go back. I mean, nail tests can go back 9 months. And so, these hair follicle tests are like looking at tree rings. I mean, they can pinpoint pretty concisely when the use last occurred. Obviously, if a client's in active use, he or she is really not ready to assume the responsibilities of parenting children. Is somebody in recovery? Has someone been to treatment? If they have been to treatment, are they doing any kind of follow-up? Now, obviously, that's an individual choice for each person. A 12-step program may work for someone, and someone else may enjoy doing counseling. Someone else may do something that's faith-based. Someone may do nothing at all. Now, sometimes the continuous recovery program participation looks really good to the court and demonstrates a commitment to sobriety. And so often, if a client's able to say, I haven't used since this particular time, the court can look favorably on that. We often advise that clients who are in recovery, who are wanting to, address maybe terminating a guardianship, establishing visitation again, we really advise that they have a continuous length of time where they haven't been in active use. I usually advise 6 months at least, and some courts, depending on the jurisdiction and the judge's preference, even look more favorably on something more like 12 months. Again, we talked about this before, but does the client have safe and stable housing? And in that safe and stable housing, how big is the house? How many children are there? What are the sleeping arrangements going to be? Does the client have the financial ability to take care of the children? Another thing that really kind of can demonstrate a commitment to recovery on the part of, the person who is seeking to change these things in their situation is being able to show that, they can hold down a job steadily. Some people that we help are disabled, and that's not an option, but they will have the financial ability to take care of the children through maybe SSI or through SNAP payments, the child tax credit. And so they're not necessarily penalized in a custody decision for that source. But for people who are able to work, it does demonstrate some commitment to recovery that courts tend to look favorably upon. And kind of what we were talking about before with environment, does this person in recovery still associate with people that they used to associate with before they were able to get in recovery for their substance use disorder? obviously, do they still use controlled substances, misuse alcohol or prescription medications? They're not ready. I mean, ultimately, the goal of this program in general, beyond opioids, is to help families who've been impacted, by substance use disorder. And so, just like the court's going to look at the best interest of the child, we want to work with the client to determine what's in the client's children's best interest. Obviously, if there's some active use going on, now's probably not the time. So another domestic issue that we see and assist with are orders of protection. We see this in our clients who are the family member of someone who is in active use, or often someone in recovery whose partner is still in active use, or even someone who is still impacted by substance use disorder. I mean, they obviously still, deserve the same safety and protection that anyone would. And so to issue an order of protection, there has to be some sort of domestic abuse that's shown. There can be imminent fear or threat of physical harm, actual physical harm, bodily injury, and an order of protection can be granted against any family or household member of the petitioner. So obviously a spouse, boyfriend or girlfriend. Also, people don't realize it can be an ex-girlfriend or an ex-spouse, the parent of the person committing the domestic abuse, the child of the person, people who've lived or used to live in the same household. People kind of often think that they may not be protected because they aren't married or formerly married, but have they lived in the same household together, then yes, they can avail themselves of the order of protection. Any couple that's got a child together, they may not have ever lived together. Uh-oh. Okay, so what's the process for getting an order of protection? The client will file for an order of protection where they reside, or where the abuse happened, or where the abuser currently resides. The process is the party goes to file a petition and a proposed order with the county clerk, especially in my counties where there are kind of some rural jurisdictions and counties that have their own local rules. This process will be different. And so because it varies from county to county, I often advise people to contact the clerk before they go up there to start the process, just to verify that that's what they need to do. Because in some jurisdictions, the prosecutor actually has a specific either attorney, victim witness coordinator who guides the domestic abuse victim through the process. And so that's kind of a special consideration to make that does vary. There's no fee to file for an order of protection, which is definitely beneficial, especially for our clients who, again, are really experiencing poverty. So the person goes and files the petition. Ex parte, the judge can grant a temporary order. And so obviously ex parte, it's entered outside of the presence of the person, who's being sought, like who the petitioner is seeking the protection from. So if the ex parte order is entered, there has to be a hearing within 30 days. Okay, the next issue that we see a lot and help folks a lot with was criminal record sealing. So what is criminal record sealing? We've probably heard people say things like getting your record expunged. I think that was kind of the most common terminology until recently. But basically, it's just the limiting of access to a person's record of conviction by certain people. And so we'll go over that in just a second. So you can petition to seal misdemeanor convictions, felony convictions. There are some felony convictions that are ineligible by statute. You can seal a record of arrest. You can seal a record of your case that was null pros or dismissed, or you were found not guilty, or you were arrested and ultimately the charges were not filed. So, at first blush, you would think, well, isn't a conviction, isn't that the worst thing? Like, why do you care about anything else? But you'd be surprised how many of these people are being held back by records of things like arrests or records of null pros. Because when people are running these background checks, like let's say through the Arkansas Crime Information Center, that's the background check that we use, and that ACIC recommends people to use to file these petitions. Often they're not right. they may have the arrest and there was a disposition in the case and there's no disposition listed. They may have it listed that the person was found guilty or pled guilty to a certain level felony when in fact it was negotiated down to a different level. And so if that's all that someone is looking into their background and seeing, it's inaccurate and there is benefit to sealing that record. And so when a client has had their record sealed, they can legally state when they interview for jobs or try to obtain housing that they've not been convicted of a crime. These are the areas that sealing your record can help with, getting a loan, getting a student loan. Obviously, we talked about employment and housing. I see a lot with my clients is peace of mind. My clients who are in recovery, you know, they've done what they're supposed to, they've put in the work, and they're trying to shut the door on a part of their past that was really harmful to them. And it helps with that process to seal their criminal record. So there are certain things a record can't do. Just because you have your record sealed, it doesn't automatically allow you to become guardian over another person. So that's what we were talking about before with one of the requirements that you are a convicted and unpardoned felon. It's not going to prevent you from having your record used against you at trial, i.e., you know, your testimony or your credibility being impeached by record of your prior offense. There are still people in law enforcement and certain types of employers who are going to be able to see it. And a thing we get asked about a lot is gun rights. You know, just sealing my records, if it's a felony, automatically restore those. And no, that's an entirely different process. Okay, we kind of went over that. So before you can seal your record, you have to pay any outstanding fines, fees, restitution, any conditions of probation that were ordered. In this particular population, the majority of those that I see are, you know, drug and alcohol treatment through probation, or if the judge has ordered through a specific program. You know, if these convictions are related to some of the offenses we talked about earlier, where there's a statutory statutory driver's license suspension, the client has to pay all their fees and they have to do anything else to get that license reinstated. And then there are certain misdemeanor offenses where there is a 5-year waiting period before, like between the conclusion of the sentence and when the applicant can apply for a petition to seal. So these are some of the records that cannot be sealed. And I've screwed up on my poll again. I'm so sorry. I can't figure out how to see when those are going to pop up. So what I was going to ask is records that can't be sealed. Can someone have their records sealed who has spent time in the Arkansas Department of Corrections? And the answer is that that person can. Up until very recently, this summer, anyone who had spent time in prison for their conviction was not eligible to have their record sealed, even if it was one of these eligible offenses. And so that's been a big help for a lot of our clients moving forward. But we're still trying to get the word out that you're still eligible to have your record sealed, even if that is one of the case, or if that is the case. Like I said, there are these waiting periods. There's no waiting period for the majority of misdemeanors, but there are these specific ones that are laid out: battery third, domestic battery third, these 3 different kind of sexual offenses and negligent homicide. There are also various statutes that someone can have their record sealed pursuant to. So this explanation of the felony waiting period is specifically referring to Act 1460, which impacts convictions with sentencing dates after January 1st of 2014. Okay, I have a poll coming up and I think I'm not going to miss it this time. Okay, yes, all right. So our next area of law is housing and how that impacts SUD, OUD clients. So the question here is, substance use disorder is recognized as a disability under the Fair Housing Act. So that's a true or false. So if you'll just take a second to vote on that. Okay, Jordan, I don't know how to see the results.
Sorry, we've got about 81% of people voted.
Oh,
And I will
okay.
remind you, please go ahead and respond to the poll. You don't have to get the answer right, but we do need you to respond so we can verify your attendance for professional programs. So we've got about 17% of people who still need to respond. We'll give them just another second to respond before we close the poll out. Okay, just 6 more people. Just make sure you respond so we can verify your attendance. All right, we'll go ahead and close that one out, Sarah.
Okay.
Okay, and everyone should be able to see the results now.
All right, so good job, 65% of you. It is in fact recognized as a disability under the Fair Housing Act. So there we go. Okay, so we'll get to that in a minute, but what do we mean by housing? So issues that we see with the SUD population are landlord-tenant, evictions related to substance use disorder, past substance use disorder. And really these landlord-tenant issues are more universal. I mean, they're just service areas that we provide at the Center for Arkansas Legal Services. Specifically with SUD clients, you're going to see the public housing discrimination issue. So as we just heard, there we go. So what do we mean by that? So the Fair Housing Act prohibits discrimination in housing based on race, color, national origin, religion, sex, disability, or familial status. So substance use disorder is recognized as a disability. However, current use cannot constitute disability under the Fair Housing Act. So, you see the word what constitutes current use, MAT, that's better known as medication-assisted therapy. So particular for opioid use disorder clients, that would be methadone, Suboxone, things like that keep someone free of, using the opioids. That's kind of a gray area right now as far as whether that constitutes current use or not. Okay, so what protections do people with SUD get under the Fair Housing Act? So a landlord cannot refuse to rent to the SUD client, to sell to the client because they have a substance use disorder. They can't force them to live in a special part of the complex. They can't charge them extra, and they can't refuse to rent to them if they've gotten treatment. And a lot of people see this, they won't even be in active use, they'll be in recovery, and somehow the landlord or the public housing agency will get wind of the fact that they've had it in the past or had treatment for it, and discrimination becomes an issue. So the housing provider always has the option to restrict housing if someone's conduct causes a direct threat to the health and safety of others. So occasionally this may come up in a public housing discrimination case with regard to SUD. So unfortunately, these federal subsidized providers have a pretty wide array of discretion when it comes to past drug-related convictions. That can be, there's some pretty, again, ambiguous provisions with regard to what crimes can be used against people, how old they can be, what they mean. And one thing you'll hear under when people talk about the Fair Housing Act is reasonable accommodation. So for our SUD clients, that's going to be procedural changes to a locations, rules, or policies that are unfairly affecting our client because of their substance use disorder. So I guess an example of that procedural change would be getting an exception if you do have a prior criminal conviction. I recently had a client at a clinic who was dealing with discrimination in that she has a service dog, but she also has an SUD, and her Section 8 landlord was trying to require that in order for her to have the service dog, she had to go to counseling every single week, which is not really related to a dog if it's related to substance use disorder. So these manifest themselves in all kinds of crazy ways. Oh, okay. I think I have another poll. Yes, okay. Sorry, this is the last one. So user and clean are examples of non-stigmatizing language. True or false?
about 80% of people who voted. And again, just please go ahead and vote. You don't have to get it right, but it does help us verify your attendance for the folks over at professional programs. Give folks about 30 more seconds. Got 7 more folks who need to vote. All right, we'll go ahead and share the results now.
All right, the correct answer is false. So the last little bit I'll talk about is how specifically you want to work with people who do have substance use disorder currently in their past. So one thing that we're really trying to work on through this program is really educating the public that opioid use disorder, substance use disorder, alcohol use disorder are diseases, are medical conditions. They are not character flaws, lack of willpower, anything like that. And so part of this campaign is using more clinical terminology that is intended to fight stigma. And so through Beyond Opioids, and I'll show you how to check this out later in the presentation, but we have a Say This, Not That campaign where we're trying to raise awareness for this particular issue. And so, rather than drug abuse, we say substance use, we say misuse of prescription drugs. And honestly, especially with prescription drugs, that almost gets the point, across easier. So habit, user, those are all things, again, that have a negative connotation and imply some sort of failing. Clean, same way, because basically the implication is that you're dirty if you test positive. We tend to say person in recovery, person whose substance use disorder is in remission. So you'll see opioid substitution replacement therapy. So what we were talking about earlier, that medication treatment for OUD. Again, it's being treated as a medical issue. And when you say things like opioid substitution, it becomes really easy for the misconception to spread that you're just replacing one addiction with another, one disorder with another. So how do you effectively represent OUD, SUD, AUD clients? In my experience in the program, you really have to meet clients where they are. And particularly with my client base, because, a lot of them are newer to recovery. A lot of them, or not all of them, most of them, all of them come from rural parts of the state. Yes, as an organization and, as a movement, as, a greater movement as a whole, we do want to spread awareness about using non-stigmatizing language. However, when you toss out OUD or SUD to your client and they have no idea what you're talking about, you do have to change your terminology to understand where the client's coming from. And that's the next place, is establish trust and rapport. And so sometimes when, you come in with that really clinical language that we want people to use, that can cause clients to be distrustful of you, to sound like you're too far removed from their substance use disorder, their experience, their legal problems. And so it's really, really important to just meet people where they are. So a lot of times when I'll be doing, say, an interview with a client initially to find out more about their legal issue, I'll need to tell them, I am not asking this to cast any sort of judgment on you. This question is only necessary so that I can be the most effective lawyer for you. Because for so many of our clients, these questions about their substance use, the type they use, the consequences they may have had, the length of use, they've all been asked to imply that these people are bad, not that these people have a disorder, a disease. And so, of course, we need to know those factors because they're going to come up. They're going to come up in a custody action, a guardianship. And so we're not finding them out to judge the party. So again, kind of like we were talking about with some of those family law issues, are you ready? Are you still in active use? Like, now is probably not the time. We want you to have the best likelihood of success in your legal action. And this is especially important in these family law issues, the guardianships, the child custody. How long have you been in recovery? Has it been consistent? are you participating in anything ongoing? Again, do you have stable employment? Do you have stable benefits? Some of our clients, if they've been incarcerated as a result of their substance use disorder, need help getting certain benefits reinstated, once they're pursuing reentry. So again, safe housing. What about your criminal legal issues? Does a court want to, not want to, but is a court willing to honestly entertain a custody action if you got arrested in September and with drugs and your child in the car? Like maybe not, like maybe this is not right to pursue right now. Doesn't mean it's not going to be right. Doesn't mean your recovery is not going to be successful. We want your legal issue to have the greatest likelihood of success as possible. So how can you help? We would love your help. So at the Center for Arkansas Legal Services, we have a program called Vocals. It's a volunteer organization for the Center for Arkansas Legal Services. And what Vocals assists with, and this is not exclusive to SUD clients, this is all of our client base. Our Vocals attorneys provide pro bono services to our clients. We as an organization go ahead and conduct the intake, determine what the legal issue is, what sort of area of law it's going to be in. And then we have our network of pro bono attorneys, and we can refer cases to them. We can ask them to review cases for possible representation based on their preferences, their practice areas, where they're located. If you're in a specific county, if you're in, I don't know, Logan County, maybe you don't want a case in Pulaski County. So we have a fabulous pro bono coordinator here in Little Rock. His name is Yvonne Martinez, and I have included his information there below. And he is wonderful and works really, really well with all of our pro bono attorneys. So if you're even remotely interested, I would strongly suggest contacting Yvonne. And then finally, if you're interested in more information about the program, we have a very new, very snazzy website that is live, beyondopioids.org, where you can learn more about the program, more about our consortium of partner agencies. We've recently got a new Facebook page uploaded too. So we have a lot of that language about, kind of eliminating stigma surrounding SUD, OUD. And then we also have this below, the VIP helpline. So if you know of someone who may need legal intervention because of a substance use disorder, opioid use disorder, this number is a direct line to intake, where we can immediately talk to SUD, OUD clients and see if we're able to provide them legal services. We also have a general helpline number for non-SUD, OUD people, but this one is specific so they can get to the Beyond Opioids program a little bit faster, since that's kind of the crux of their legal issue. So that is about all. If there are any questions, I'm happy to answer or try to answer them.
And Sarah, while we're waiting for folks to post their questions, which they can do in the chat or in the Q&A, I do want to remind folks one more time where they can find the materials. That's at arkansasjustice.org/breaking barriers. That's in the chat. You'll find the materials there and the CLE form. You do need to return the CLE form to cle@arkansasjustice.org by Friday if you want CLE credit. And Sarah, I do want to go back. There was one question that I saw earlier that I think you addressed some, but maybe we could expand on a little bit. Is a parent in active use alone enough to lose custody, or for guardianship over kids by another family member?
Sadly, yeah. I mean, and part of that is because it's, again, it's ultimately at the judge's discretion. It is kind of a totality of factors, but we have kind of empirical evidence that with active use, substance use disorder comes a lot of other problems, comes, financial instability. Can you provide for the child? The possibility of putting a child in harm's way. And we have plenty of people who, they're, nobody's perfect, and someone may, dabble in recreational or non-recreational drugs when they're not in the presence of their children. From my experience, that doesn't seem to be enough to overcome active use, as a parent or as someone seeking to get custody or visitation reinstated. It's really something that we want people to be in recovery and really demonstrate a certain amount of months of recovery just to be able to show to the court the stability.
We'll keep an eye out for questions, but one thing I was hoping you would address here at the end, Sarah, we had at least one member of the judiciary join us today, I know. So we've talked a little bit about what attorneys can do differently, terms we can use that are more appropriate. What's one thing you would like judges to change about how they handle substance use disorder in their courts? What's something our judiciary could change to help folks get through recovery?
I feel like I would have been better able to answer this if you hadn't already told me there was a member of the judiciary on here. Honestly, it's more of the same, really. It's reframing this idea that a substance use disorder, particularly in someone's past, is a character flaw, is evidence that someone is not capable of being a good parent. It's evidence that someone at some time wasn't capable of putting, you know, their child's best interest first, but also seeing, you know, that it is, that it's like recovery is the result of a lot of factors, and it's not just being substance free. And I think people can really demonstrate their commitment to what they need to do as ordered by a court to get their kids back by their commitment to recovery. And so, and I guess the other thing I've seen is medical marijuana. I guess when people have a prescription for that, it's sometimes still being used as like a positive drug test, or a reason that a factor in a court's decision to not modify visitation, not give custody. And so, you know, that is now legal, and it's now a medical substance that people are allowed to use, but it still seems to be a little bit misunderstood.
All right, I am doing one last check for questions. I don't see any. So I'm going to repeat myself one more time. If you need the CLE form for today, it's at arkansasjustice.org/breaking barriers. And I'm sorry, I'll put it in your chat one more time, just in case anyone needs it. As you leave the webinar today, you'll be asked to fill out an evaluation. Please do share with us what worked today, what we could do better. We appreciate that feedback. Thank you all so much for being here. Sarah and I, if it's okay, Sarah, we'll stick around for just a minute or two more in case anyone has a question as folks are leaving. Thank you so much for joining us today, and thank you, Sarah, for presenting.